And so I want to let Greg McNeal, who is from Pepperdine University, I should give him an introduction, the School of Law, or Law School.
And the School of Public Policy.
And School of Policy. So he is here with us today to talk about this issue, which he has dealt with. And it's interesting because there are some web sites that have done some interviews with Greg. And so that was one thing that intrigued me, in addition to some of the stuff that he's presented at conferences. So I think it's a real privilege to have Greg here. And for those of you who are still here, we are going to have a Q&A after. And so be ready to ask these folks questions. So without any more, I will turn it over to Greg.
Thank you.
I'm going to wear this because there's no guarantee where I'll end up. I was joking before that, I might work my way into the crowd because I know I'm the last speaker and I know that you might be getting a little tired. And so I might need to sit next to someone and make sure that they're not falling asleep on me. Okay, so thanks for the introduction. Thanks for having me here. I should give you a little bit of background. It's funny how I got into this. My area of research is security, technology, and crime. And so what does that have to do with agriculture and pest management and the types of things that we're talking about? Well, the technology component of it actually is pretty interesting. So there's a line of innovation and regulatory work that I was working on, and I was working on drones on the, I'm gonna use the D word, so if you're opposed to that, sorry. So I started working on drones on the military side, and then what was funny was journalists started calling me and saying, hey, you've worked on these drones on the battlefield type of thing, targeted killings overseas. What do you know about FAA regulations and drones? And because I not only have a PhD, I also have a law degree. The law degree you sort of confers on you this arrogant thought that you think you can answer anything about anything. Like if you ever meet a med mal attorney, they think that they're a doctor, right? Because they deal with doctors all the time. So I had that moment and I just sort of ran with it. And I started getting into the field, starting advising startups, and the startup companies that are involved in drones right now are really very interested in precision agriculture. That's the low-hanging fruit, the biggest industry, most of the industry analysts have thought, but it's actually getting into a lot of other areas. And so inspecting, environmental monitoring, there are all kinds of applications that we're seeing that are coming online where it's not clear to me that the precision application of pesticides or precision farming or those types of things will necessarily be the leader. And so that's a little bit of background on this. And so since in the 3 or 4 years that I've been, maybe 4.5 years that I've been involved in unmanned aircraft, I'm now on the ASTM technical committee creating the scientific standards for the operation of unmanned aircraft. I testified last week before before Congress about unmanned aircraft, and I'll be testifying next week before the California Senate about drones. And so just a wide range of experience that this will give you some insight into the bigger legal policy and regulatory picture as well as the legislative outlook. And so in places where someone else has already covered some of the issues, I'm going to move past those relatively quickly unless I think I can add something that wasn't already mentioned. So let me hop into it. Hey, I'm a lawyer, I'm doing the legal update, and so I apologize that this will be a deep dive into the legal weeds, but I'll try and tie it to the stuff that's important for you to keep it interesting. And so first, here's an important definition for you. The FAA, so there was a guy named Perker who flew a foam model airplane at the University of Virginia campus to film the UVA campus. And he flew it low, he flew it under buildings, and in the end, his observer caught this foam aircraft with his hand. Then he posted these videos online, and the FAA came after him and fined him for reckless operation of an aircraft, specifically because of the low altitude at which he was flying this foam model airplane and because his operator caught the foam aircraft. It was like as if he had flown a 737 into his co-pilot. And so Perker gets fined $10,000 and he fights back against the FAA and he says, you know what, I'm going to challenge this. It's not an aircraft. You haven't promulgated any regulations to govern the operation of unmanned aircraft, and so you can't come after me. It goes to an administrative law judge where Perker wins the case. The definition the FAA wanted to use was a definition similar to this, and the administrative law judge said, no way is that the definition of aircraft, because if it's any device that's capable of flight, then that's balsa wood airplanes, that's footballs. So it cannot be the case that this statute where you say that you have the authority over aircraft can actually be applied in Perker's situation. Anyway, the FAA appeals, it makes it to the National Transportation Safety Board, and they say an aircraft is a device that's used for flight. We acknowledge the definitions are as broad as they are clear, but they are clear nonetheless. So what does that mean for you? It means that if you're planning on tethering your drone, you're actually not getting around the aircraft definition and that the FAA applies. And so I've been at multiple conferences where the FAA says a drone is an aircraft, the device that's capable of flight is an aircraft. If there's not a pilot on board, it's unmanned. Therefore, your tethered drone is just as subject to the rules as an untethered drone. And so people have tried to be creative here. There are businesses that have tried to create tethered drones. And it is not a balloon, right? There are actually separate FAA regulations dealing with balloons, aerostats, and other things. And so I say that because, not to pick out the example that you provided before, other than I don't want you to get into legal trouble. None of this is legal advice, by the way. I'm not your attorney. If you want me to be your attorney, just pay me some money, I'll be your attorney, but I'm not yet your attorney. And so just recognize how broad that definition is. And so what I like to tell people at industry conferences is that if you think you've found a creative way to avoid the FAA or regulatory sanction, you probably haven't, right? And that's just, like if you think you found a creative way to speed through a residential area, you've probably misread the local ordinances with regard to speeding. And actually, after just a few days ago, there was a recent Supreme Court case that said if an agency, an administrative agency, the FAA or other agency, EPA, that'll matter for you guys, agriculture, has for decades interpreted a regulation to mean one thing and then pulls those regulations out and the next day issues a memorandum and says that we now interpret the regulations to mean something else. The Supreme Court said that doesn't even have to go out for public comment. They can just do that to you. And so that's the type of power we're dealing with broad enforcement discretion on the part of administrative agencies at the federal level. And so just recognize how big the definition is. And so there's a drone. That's an aircraft. It's a device capable of flight. It's actually a quadcopter drone that somebody rigged up to look like a speeder bike. I actually think it's pretty awesome. And so what's the current regulatory environment? We touched on this, but let me give you the broad framework. If you're flying for commercial purposes, it's illegal unless you have a 333 exemption. If you're flying at a university, it's unlawful if it's at a public university, it would be unlawful unless you have a COA or an experimental certificate. And a COA is a certificate of authorization. If you're flying at a private university, it would also be unlawful unless you have a 333 exemption because private universities are not eligible for COAs. The COA basically is the authorization to fly, and it also, if you're a public entity, it allows you to self-certify the aircraft without going through the 333 exemption process. So big news, Amazon got an experimental certificate. They applied for it 6 months ago. And the FAA granted them an experimental certificate. Today, their head of regulatory affairs testified before the Senate Commerce Committee that they no longer fly that aircraft because by the time their approval was done, that aircraft was already out of date. And so they're trying to experiment and innovate at a rate that is faster than the regulators can keep up. And so what have they done? They're flying overseas in the UK, where because the current experimental certification process, imagine you've got a quadcopter drone, something very similar, and it has 4 legs that are 6 inches long. You would submit those plans for your experimental certificate, and then if you decide that you want to add a quarter piece of foam to the bottom or rubber to the bottom of that aircraft. That would be a modification to the aircraft that you would then have to go back to the FAA to have someone approve that modification. Now imagine that the review process of that alone might not take a very long time, but the backlog and the personnel matters associated with it might actually take a lot longer than you would want. And so Amazon made pretty clear today that they're not very happy with the experimental process. And then there's the 333 exemption process. That refers to the FAA Modernization and Reform Act, Section 333. It's an exemption process that was actually written into the law. When Congress passed the law, industry went to Congress and said, hey, we want a process where we can't wait from 2012 till 2015 for the regulations to be passed. We want, if we're ready to go, we want a path to get an exemption. And actually, it's been one of two of the most effective sections of the bill, where basically the end run around the regulatory process to ask for exemptions from the FAA's rules. There's a lesson for that I'm going to talk about in just a little bit. FAA promises a 90-day turnaround. That's not 90 real days. That's 90 business days minus federal holidays. So they've been missing that 90-day mark. It's been closer to 120. I haven't done the math on whether they're hitting it on 90 business days or not. Do you know if they're hitting it on? Yeah, I haven't looked at it, but it's basically count on about 120 days, and then 90 days for each modification. It used to be, and I'll talk about this in a second. I'll talk about it now, and you'll see it on the slide in a second. You would get a 333 exemption, which basically said, I plan to fly this type of aircraft over my farm within this geographically bounded area. Here are my flight procedures. Here's my pilot in command. Here are all these other things that I'm doing. And then for each individual flight, you would have to coordinate for the geographic area in which the flight would operate, the COA, plus you would have to coordinate with the flight safety office in your regional area. They've announced today that they're streamlining that process such that if you applied today, 90 days from now, 120 days from now, you would get a 333 exemption for your farm or your test facility or wherever it is. And so long as you stayed under 200 feet and you otherwise met a series of other restrictions, don't fly over people, don't fly within 500 feet of an airport, stay within direct visual line of sight, you wouldn't have to do the coordination with the FSDO or get individual COAs. That sounds a lot better, but I look like a tall guy in Munchkin Land, right? I mean, that's just, when the bar's on the floor, everything sounds awesome. So the alternative, of course, could be to go to Canada or Australia. So this is the current regulatory environment. Today's developments, the new and existing 333 exemptions now come with the blanket COA, and the FAA is going to engage in summary approval of similar 333 exemption requests. Hugely important to you if you are a person who's thinking about flying but does not have a COA, does not have a 333 exemption. What this means, let me add one other development. The other development I learned about just like a few minutes ago is that they're now, so the 333 exemptions have required that the pilot in command of the drone be a certified commercial rated pilot. They just granted a bunch of exemptions today where you only had to be a sport rated pilot. That means 15 hours of flight time in an airplane, in a Piper Cub or a Cessna, so that you could fly a remote control helicopter that my 3-year-old can fly. But it is as low as the FAA believes they can go under the statutes that they're dealing with. And so in any case, that might make it a little bit easier to be able to fly if you get the 333. But the other thing is that summary approval of similar 333s means if the guy at the farm next to you or the gal at the university next to you got a 333 exemption to fly a DJI Phantom or some other aircraft, right? Some fixed-wing aircraft, an AeroVironment Puma to a Precision Hawk, something else. If they got that exemption to fly over there based on a certain set of criteria, and you say, I just want to do what the guy across the street is doing, you can nearly duplicate that individual's procedures and file your application saying this is similar. And if the FAA believes that it's similar and your scope of operations is the same, they have now said that they're going to do summary grants. That was announced. I don't know if it was in writing, but it was announced today by Deputy Administrator Gilligan in the Senate Commerce Committee hearing. Now that means you have to actually be doing the same thing, right? And so there are a variety of factors that could change the risk picture, right? So if you're flying with certain chemicals and the other people are flying with cameras, I think that changes the risk picture such that they might make it a separate approval process, because a crash with chemicals is different than a crash with just a camera on board. And so, don't get too optimistic about the similarities, but recognize that that's a possible path to speed things up. What's coming in Europe, though, is important for us. And so if you're thinking about developing your technology, selling products, cast your eyes across the Atlantic. The European aviation authorities announced that a new regulatory framework that they're going to be editing, basically doing their drafting commentary period on in June. And then they're going to have finalized rules out for comment to the European Commission for approval and review by the European Commission by December. That creates 3 categories. The open category is a category where the European aviation authorities simply do not care what you're doing. It'll probably be your DJI Phantoms and other stuff, so long as they stay below a certain altitude and outside of certain areas. They don't want anything to do with it, and they're subjecting it to local police control. So they're just so it would be as if the FAA said, you buy a Phantom online, you buy a 3D Robotics Iris online, or a Parrot, whatever. Don't worry, we're not concerned with what you're doing if you keep it below 500 feet. And if it bothers people, go call your local police department, because we're not concerned about that. Then there's the specific category, which is a wide open category based solely on a risk assessment. So if the Phantom is going to be flying at low altitude over people, you might move from the open category to the specific category, and that risk-based category, the approval for the flights will be done on a case-by-case basis based on what mitigation steps an individual is taking. Sometimes those mitigation steps, for example, if you're flying at 400 feet over people, might be that you have some fail-safe procedures like a parachute or backup systems or redundant systems, et cetera. But they anticipate no ceiling to the specific category. So that means that you might see 55-pound crop sprayers, so long as they are mechanically or electronically governed to stay within certain geofenced areas and below a certain altitude, may very well be approved to fly in the specific category, even though they're very large. And in fact, I say 55 pounds, it could be 500 pounds. In their comments about the certified category were the category of aircraft that would present risks to manned aviation, or risks similar to the people on the ground that manned aviation would present to the people on the ground, or would require approval by aviation authorities because of political or practical reasons. Practical reasons being like it's entirely too complex, and political reasons like an Airbus-sized aircraft, an Airbus 320-sized aircraft that is flying without a pilot on board with people inside, is the type of thing that for political reasons, even if you have all of the empirical evidence and scientific studies in the world to say that it's safe, you might just want someone to like stamp off on that. And they actually just like, I'm paraphrasing a little, but they say an Airbus or a 737, you probably for political reasons want a certification on. Those are their 3 categories. And so what that means for R&D is that if you're planning to develop a system for a European market, you take a look and you say, you know what? As long as I can prove that it's safe and I've mitigated risk, I'm at least in this category. I might even be better in this category if it's depending on how the size restrictions and operational parameters work out. All right, so timeline on the American Notice for Proposed Rulemaking. My claim to fame, I ruined the Secretary of Transportation and FAA administrators' President's Day weekend, because on the Friday of President's Day weekend, somebody sent me a copy of the economic analysis report of the FAA's Notice for Proposed Rulemaking, which is the report that says what will the economic impact of these rules be. And so somebody sent it to me and I read it and I was like, oh my gosh, this is like important. And apparently someone like fat finger accidentally posted it to regulations.gov, and it was up for 1 second while some guy was on there, and he quickly like downloaded it to his computer, and then it disappeared, and that guy sent it to me. He's like, do you know what this is? It looks important. I was like, very important. So I wrote it up and summarized it by Saturday morning. Like the The Wall Street Journal and Associated Press were crediting me with like breaking the story that then forced the FAA administrator and the Secretary of Transportation to hastily announce the regulations on the Sunday morning of President's Day weekend. I work every day, so every day is a Monday to me. So if I'm ruining somebody's Sunday, I'm feeling pretty good about it. And so, sorry, I'm from Jersey. I realize you people are nice people, but I'm from Jersey. So in any case, that's my little claim to fame. So what do you get? February 15th, they don't actually open them for comment until February 23rd. So it's a 60-day comment period that can be extended by the FAA. So it's either going to close on April 24th or it's going to close on May 24th. Plus or minus a day if I screw the math up somehow. And so from that, though, then they might get thousands of comments, and so we'll see how long it takes them to finalize the rules. So we might not be looking at finalized rules until 2016 or 2017, which means if you don't have a 333 exemption, you're not flying until 2016 or 2017, probably late 2016, early 2017. And we have had a history of the FAA being late on things. And so factor that into your process. I think the smart move is probably to get a 333 exemption at this point if you see any type of unmanned aircraft operations or experiments that you want to do between now and 2017. Now you might be thinking to yourself, people are flying all the time and they're not getting in trouble. Well, enforcement action is ramping up, that's one. Two, your competitor, if they go through and get a 333 exemption, is the first person likely to call and narc on you because they're your competitor. And what are the consequences of you flying without a certificate, without a 333 exemption? When the rules are finally passed, if you're a person who is flying not in compliance with the rules, the FAA will deny your ability to get certified to fly under the new rules, and they can give you a lifetime ban on you, your entity, and anyone who flies subordinate to your entity. So if you're a company or a university, if you're a university, your hose, your company, declare bankruptcy, open under a new name, and you're no longer a part of the company. And so will they do that? I don't know, but listen, the cost is dropping on 333s now because it's becoming very easy to do them. I did one for a very simple application. It cost the client around $5,000. I did one that cost around $10,000. People are doing them ranging from $5,000 to $40,000 depending on the complexity of it. I could see how at $40,000 someone wouldn't want to do a 333 exemption, but at $5,000 you're just starting to talk about the regular cost of doing business, and so weighed against the risk of not being able to ever be involved in this industry. You do that calculation on your own. I used to tell people that the 333s were too complex and too expensive, but now after the recent developments in the last few weeks and some certainty as to what's coming down the pipe, I think that the 333 is a better idea than I had previously thought. So the small rules, the rules will be codified in something that'll be known as Federal Aviation Regulations Part 107. They'll be enforceable in the same way as other regulations, which means they're enforceable through civil penalties, possible criminal penalties. And again, they'll take certificate action against unsafe operations or operations that are outside of FAA regulations. Certificate action means they pull your license and you can't fly again. Now, hobbyists are not under these rules. Hobbyists don't need to comply with these rules. Instead, they're governed by model aircraft rules. Model aircraft rules basically say that you fly in compliance with local community guidelines created by a national organization intended to support the flight. Okay, so people have shortened that description to be, well, you have to be within 500 miles, outside 5 miles of an airport, under 400 feet, within line of sight, under a certain weight. That's a nice rule of thumb. The lawyer in me is a little worried about it because if you actually look at the community guidelines for the Academy of Model Aeronautics, which is really the only community guideline-based group out there, they have far more restrictive rules than just those mere rules. It's like fly at a park, be insured, right? And so if it's fly at an approved site and be insured, then you are not flying in compliance with Model AMA guidelines, community-based guidelines, if you're flying in your local park, because you're not in an AMA park. And so the paranoid lawyer in me thinks that somewhere down the road, we're going to start to see FAA enforcement guidance against model aircraft users and hobbyists basically saying, actually, you know, the AMA guidelines require you to be an AMA facility and under a certain weight class if you're not, and that weight class is really low, like 2 or 3 pounds. And so I'm a little paranoid about it, and I actually think that's what's going to be coming, especially because in today's hearing, it seemed like the tenor of a lot of the comments were commercial operators are okay. Government will deal with those operators at another point in time, but these darn hobbyists, and not really the hobbyists, the recreational flyers are the problem. Because the hobbyists are the ones who go to the AMA field. The recreational flyers are the ones who buy it at Amazon and they're flying it in your neighborhood. And those are the ones that are getting everybody pissed off. And when you get enforcement professionals pissed off and legislators pissed off, that's where the enforcement action starts to come. And so I would watch that. Now, if you're thinking to yourself, I'm doing all this pest stuff, it's my hobby. I'm doing all this agricultural stuff, it's my hobby. You're not as creative as you think you are. The FAA has thought about that, and they've created some guidance. And they basically say if you're flying a model aircraft at the local model aircraft club, that's a hobby. Getting money for it, well, that's not a hobby. Taking, my favorite one is viewing a field to determine whether crops need water when they are grown for personal enjoyment. Your petunias, hobby. Want to make sure that you don't have thousands of gallons of pesticides running off into the river? Prohibited. We will not allow you to do that. You want to save the environment for fun? Okay. You want to reduce the amount of pesticides you're using? Sorry, that's a commercial purpose and you're going to need a 333 exemption. And so they've really thought this, through. Okay. So what type of operations will we see? This is from the FAA's guidelines. They think that we're going to see crop monitoring, research, power line inspection, antenna inspection, bridge inspection, aerial photography, wildlife nesting evaluation, that kind of thing. Note that all of these things are things that, like, you have an operator with a remote control in their hands, they can see the drone, and it's sort of just, it's just taking the ladder out but giving you an aerial vantage point. Or it's allowing you to get over the water without having to be in a canoe or something. But it's not getting beyond line of sight. And so that while they say pipeline inspection, this is pipeline inspection from here until as far as the pipe bends around the tree, and then I have to get there and be able to continue to follow. It's not the pipeline inspection that the oil and gas industry wants. It's not the power line inspection that the industry wants, which is, let me plot in the geocoded, the GIS coordinates of my pipe, launch this thing and have it fly along the pipe, taking pictures and then landing and charging at a platform somewhere on the pipe and continuing on its way. And that's why you're seeing some pushback against the regulations. Operator qualifications, they're not called pilots, they're called operators. English, 17 years old, pass a written test. It'll be $250 or something to take the test. TSA background check. No vision test, but you have to keep the aircraft within your visual line of sight. Figure that one out. No medical certificate. Just demonstrate flight proficiency, and they think it'll take 6 to 8 weeks to get you through the process, and then you have to renew every 2 to 3 years. These are the things that'll be involved in the knowledge test. It's relatively simple. I mean, people pass this all the time. It's not going to be that complex. It's like a memorization multiple choice test about, you know, what are the rules of the road for aircraft, how do aircraft operate, and then some decision-making things about aeronautical decision-making. The ASTM committee I'm on actually had a more complex set of rules, and I'm wondering if they're going to be integrated into the aeronautical test. So, for example, when you fly an unmanned aircraft out and you push to the right, it goes to the right. When you push left, it goes left. But when it's flying back, it does the opposite. And that might be something that's actually in the written test. It's one of the sort of aeronautical knowledge things that's specific to unmanned aircraft because the pilot's not on board. Beyond visual line of sight is not permitted, and so I talked about this. Even if you have a visual observer, the visual observer can watch the aircraft for you while you're watching the camera to figure out where you're taking those photographs of those crops or precisely delivering the pesticide or doing whatever else it is that you're doing while that person watches the aircraft. But you have to be able to, when they say, oh crap, look up and see the aircraft and still operate. So you can't have a visual observer further down who's over the horizon, who can see you and see the aircraft. You can't daisy chain in that way. All of this, by the way, is more restrictive than what's going on in parts of Europe. These are just some of the airspace rules that are going to operate under the new rule. Class B, C, and D airspace, which is most of the airspace that you're going to be concerned with, you'll require permission from air traffic control. So you have to actually call air traffic control up and say, hey, I'm in my field in Iowa. I'm going to be flying my Phantom. I'm requesting permission to fly over my field at 12 feet above the ground. Right? I'm doing strawberries, right? There's no reason to be above 10 feet when you're taking imagery of a strawberry field. Maybe you'll be at 20 feet if you're trying to get wider imagery, but if you want to get down to like somebody told me the value of, you guys would know better than I would, the value of strawberries are like $50,000 an acre. And so the importance is to get down like close to the strawberries and see if they're being damaged in some way, so you can section off that part of the crop and save it. So you're at like 10 feet. You'd have to call air traffic control to be at 10 feet of altitude. It's something that hopefully will get worked out in the comment period. Can't be over 55 pounds. You need 3 miles of visibility. So you need 3 miles of aeronautical visibility, through the airspace. Like get that report from NOAA about 3 miles of visibility so you can fly at 10 feet above the ground or at 15 feet above the corn rows. Yield the right of way. You're subject to all these rules. Cannot fly directly over persons. If you're dealing with agricultural circumstances, there is a clause in there where it'll say things like, you can't fly directly over unprotected persons, and so the person should be in a structure. Open question. If I'm in my John Deere and it has a roof, does that count as a structure? What if it has a roof but no windows, right? So it's not a fully enclosed cabin. I just have a roof over top such that the drone could fly through the front and give me a bloody nose. Is that considered protected or unprotected? I do not know. The problem is that not knowing means that there's enforcement discretion on the guy with the badge when he comes out. There'll also be reporting requirements for accidents. And the open question, the regulation about the reporting requirements in the accident is what counts as an accident? So I've got my little quadcopter. I'm just going to take some pictures of the field so I can or I'm just going to fly it up to find where my lost cattle are. Or I'm going to fly it to figure out where I left that backhoe, right? I remember it was somewhere, right? I actually heard in the testimony today that apparently in apple orchards, it's really easy to lose your equipment in apple orchards. And so the guy testifying in the Commerce Committee hearing today said that they just sometimes fly their drone up to find their lost equipment because they don't remember where they left their tools. So you spin it up and the blade spins up and nicks your finger. Is that an aircraft accident? Nicks your finger requiring stitches? Lops your finger off? At what point in time is the injury serious enough that it requires you to report? Because the reporting requirements are going to be aggregated in some database and might have implications for insurance. All open questions. Smart thing to do, CYA, which is cover your or call your attorney. You just pick which way you want to do it. So we talked about registration and markings. What's interesting about registration and markings is that registration makes sense and markings make sense for a drone that flies off and crashes. We can figure out who was flying it. We can get it back to the operator. But if you're looking up and you're wondering, I'm about to send my crop duster out and there is a DJI Phantom flying there, who's operating that? 12-point font doesn't help you when you're down at the ground, right? I can't read any of your, I can see Jeff's name tag, but I can't read your name tag. And so that's not very helpful. Scientists at Berkeley are working on a system where your LED lights on the aircraft would flash in a specific pattern over 3 seconds that you could point an iPhone or Android phone at it with an app that would read the flashing pulse of lights and it would tell you what the registration number for the aircraft was. But that's really like advanced forward-thinking kind of stuff. And so I'm not sure the FAA is thinking about that kind of thing yet. They're still about like pasting labels onto the side of the aircraft. Okay, so I had discussion here, but I think I have 5. Do I have any more time? Okay, let me just talk about future look. All right, so right now, the notice for proposed rulemaking is dealing with the type of stuff where a person is flying the aircraft, right? You can sort of see it. The future, though, is in autonomous operations. So I hit a button, the drone flies out, and it assesses the temperature of my field and the crops in different areas. Then if they're within a certain temperature range, it then knows to direct the larger aircraft to fly out and just water certain parts of the field, all without my human intervention. All of that's unlawful right now. We're talking 2017 to 2018 is when that's supposed to come online. So when the FAA regulations directed at stuff that's been around since 2014 finally come online, we'll already have leapfrogged past that. And that's why Europe is taking a very different approach from what the United States is doing. That's why the testimony today at the Commerce hearing was so important. Amazon basically said, we're trying to plan for the future, which is 2019, where the drones will fly on their own, beyond line of sight, have the capability to see and avoid other aircraft using onboard LiDAR and visual processing cameras, dodge those aircraft, or interface with an air traffic management system that NASA's developing that will allow aircraft to already plan to avoid one another. But the FAA rules aren't even taking account of that, or at least not that we know of yet. There's another cool drone, Millennium Falcon drone. So let me just show you the NASA thing, and then I'll shut up. So NASA is working on something known as the Unmanned Aircraft Traffic Management System. They anticipate that within 5 years they'll have prototyped it, and within 10 years the system will be technologically capable of managing airspace. And the idea is this: if you're doing an agricultural application, you would program your aircraft to fly, or your aircraft would have a pre-programmed flight path over your farm. It would communicate that to the Unmanned Aircraft Traffic Management System, and then all other aircraft would know that that geographically defined space has been carved out for you. Ultimately, the long-term picture would be that the miniaturization of ADSB, that onboard communication system that lets other aircraft know where you're at, would also communicate with other aircraft such that if a manned helicopter were flying in on a rescue route, because there's a lost child somewhere in your farm, it would communicate with the UTM and with this aircraft and direct this aircraft to descend or land because a higher priority aircraft was entering the airspace. This is all technologically possible. The testing is, I'm on the team I'm an advisor on the team that's doing some of the testing, and we're going to start testing this this summer with the ultimate goal of being on a 5 to 10 year window of this type of thing being possible. And so the big question is, will the FAA be able to innovate in their regulatory process in a way that accommodates this? If not, we might see most innovation happening overseas first. And so I'll shut up now, and hopefully I was on time. Thank you.